The major opposition political parties held a press conference during which they urged the National Assembly and the President to amend the Electoral Act. And their grounds, the major complaint that they had was the fact that the amendments that were done by the Senate of the Federal Republic of Nigeria and adopted by the House had taken out the automatic or the direct transmission of election results from the polling units to the collection center. Of course, to be clear, the value of the transmission of the election result is still very unclear, because no matter what anyone may say, the fact is that election results that will be transmitted ought to be the ones that the party agents have signed and should be holding whenever they go to the collection center, or if the cases go to court, that they will present these election results at the court of law. But the opposition political parties, has happened in 2023 and has been happening all through Nigeria's history, have been unable to put their acts together and do not do their work. The result of it is that, as it happened in the 2023 elections, several times polling agents appointed by political parties compromise with the groups that want to rig elections and the security agents on site. And they connive to change the results even before they're transmitted or even before they're taken to the various collection centers for them to be entered into the collection papers. And so for me, the issue at stake is not just about automatic transmission of the results, because you could actually transmit wrong result. Or, as I've said in the previous video, you could actually transmit, as it happened in the last election, copies or pictures or things that are irrelevant to the collection center. If you check the RF that people seem to think will solve Nigeria's electoral problem, you will see that among the things that were uploaded in the last elections were pictures, essentials, and materials that were not legible. The fact of the matter is that the political parties ought to have people at the election centers, people at the polling unit who will insist on the results being written down and will collect the results before they are transmitted. Now, as I said in the previous discussions, there has been no time in the Nigerian history, so to say, that elections are rigged without the consent of people who represent those who might be losing in the election. And this happens oftentimes at the polling unit. As I said in the previous video, in the past, we had a situation where people would simply buy up extra or unused ballot papers that had been evenly shared to them. And the person who got to the polling unit with enough money will buy up these papers and write the results the way he wants to write. I dare say that even the claims by the Labour Party that the election results were changed or what was on the array was substantially different from what their agents had is interrogate. Where are the papers that the agents of the Labour Party had that are different from what are in the array? If we keep on this discussion, we'll come back to the fact that we need human beings to stop rigging. Machines have a role to play, but human beings have a bigger role to play in stopping rigging. In any community or any polling unit where people insist that election results should not be rigged, should not be changed, that election result will not be changed until there are some people within the groups that compromise and allow the election results to be rigged, which is why the political parties need to do their work and not to hand over their complaints or their frustrations to machines. Like I said, in some European countries, advanced countries, people are actually moving away from machines because machines can be more easily compromised than human beings. With human beings, you will need thousands of human beings to cooperate to be able to rig or change an election result. But with machines, you just need a geek somewhere sitting behind a computer, not even in Nigeria, sitting in Russia, Ukraine, or India with enough technology by his side, and can stay in between the server and the results coming in and adjust the way he wants. And he just needs to do this by writing a code that does the work for him. And so for me, when we are talking about these elections, about this Electoral Act, we have to be mindful of the fact that the Electoral Act, no matter how beautifully it is written or is crafted, cannot guarantee by itself the integrity of election. It is the people that will, at the end of the day, ensure that election results have credibility. Having said this, let's take a look at the differences between the Electoral Act 2026 and the Electoral Act 2022. I got chat GPT to check to compare the Electoral Act 2022 and Electoral Act 2026. It will appear that the Electoral Act was not substantially amended by the 2026 Electoral Act. You can see that sections 1, 2, 3, 4, 5, 6, 7, and 8 remain essentially the same. The same thing, sections 9, 10, 11, 12, 13, 14, 15, 16, 17. Of course, 17 modified the identity to be used during elections and just added a new ID for verification at elections. Everything is the same up to section 19. And if you go further, sections 20 to 28 are essentially the same thing, no serious change. And then section 29 to 35 on the issues of parties' submission of names of candidates, publications, withdrawal, dates of candidates, institution of candidate nominations, independent candidature. They remain exactly the same. There's basically no difference, I must say, between the 2022 Electoral Act and the 2026 Electoral Act. Now, if you look at the election timetable, there's a modification in section 38, the modification that reduced the time to meet up with the fact that there has been a delay in the amendment of the Electoral Act. So there's a small modification in terms of the timeline, that the timeline was shortened so that it will not go, of course, still the same. On 38, 39, 40, 42. In terms of the election notice, campaign period, polling arrangements, polling agents, and polling unit setup, basically the same. If you look at the voters' voting process, section 43 to 48, eligibility to vote, voting procedure, ballot secrecy, and the use of beavers has been retained, and the law is basically the same, not much change. And then we have the section 51 to 61. And of course, we know that we had a row that led the political parties, opposition political parties, to address a press conference last week. There was a modification, of course. The modification was meant to improve the options that INEC had in transmitting election results, which in the 2022 Electoral Act simply said INEC could deploy whatever it wanted to deploy. But this time, INEC has been mandated to transmit the election results to the server. But of course, this is not mandatory, because if there's no service there or there's a network glitch, INEC will not have to. It's not mandated to do what is not possible to be done. But let's pause a little bit about this section because it has brought about a lot of controversy in Nigeria. I have made the point in the past that this section, even if it had been left, and that INEC will have to transmit the result to a central server, as many people are agitating and think that might be a silver bullet that can end election or manipulation, change of election results. My opinion about it is that even if that section had been left the way the House of Reps had done it, even if it were possible 100% to transmit the results generally across the country, the fact of the matter is that election results will still be manipulated if you don't have agents on site, or if you don't have people that are taking care of what happens at that particular unit. Because election results are declared not on the basis of that form at the central server. They are declared on the basis of procedures that are already outlined in the Electoral Act. And this will include the use of that result sheet that has been transmitted at the place where the result sheet will be transmitted. If your agents or people, political party officials who are supposed to safeguard the results have not done anything to safeguard the result, just having the result at the central server will not solve any problem, because you have to go now to the tribunal and complain at the tribunal that the result that was sent to the central server is different from the one that your agents have or the one that was collected. That will bring in a completely different matter, bring in the judiciary. And we do know that the judiciary in Nigeria does not take decisions based on what is right or what is wrong. It takes decisions based on the pressures that are placed on it, and also decisions based simply on technicalities. So what you need to safeguard your result are the agents that are there in the field. Let's go back to the Electoral Act. In terms of campaigns and political party finance, Section 68 to 75, they're basically the same and nothing has changed. Now, of course, there is a change when you go to the electoral offenses in Section 676. I think, if I'm not mistaken, the amendment removed jail terms and increased the fines. And if you go to Section 82, there's also higher penalty for trading with PVCs, as the case may be. And then if you go to miscellaneous sections 85, section 153, they are basically the same, except, like I said, electoral offenses penalties have been increased. But that is not the controversy that we are having today. However, Section 138 of the Electoral Act did something that is very strange, that appears, in my opinion, to be contrary to the Constitution of the Federal Republic of Nigeria. It says that Section 138, that an election will be questioned on the grounds that A, election was invalid by reason of corrupt practices or non-compliance with the provisions of this act. B, respondent was not duly elected by majority or lawful votes cast at the election. And then it talks about an act or omission which may be contrary to instructions or directive of the commission or an officer appointed for the purpose of election, but which is not contrary to the provision of this act, shall not be a ground for questioning the election. I believe this might be referring to the fact that sometimes INEC fails to produce the logos of some parties in the ballot papers. And so the question to ask is, the National Assembly saying that if someone goes to pay INEC officials in the worst case scenario or goes to the printer and removes the logo of your party from the election result, you cannot go to the tribunal to challenge the result. Well, we'll need to see. But this section appears to be contrary to Section 137, Section 182, Section 107, and Section 66 of the Nigerian Constitution, which provides that no person shall be qualified for an election to the office of the president, governors, legislative houses of the National Assembly, and state houses of assembly if such persons presented forged certificates to the Independent National Electoral Commission. So what does it mean? If you look at it, you will see that Section 137, for instance, in the case of the president, it's out about A, B, C, D, E, F, G, H. J was removed by the National Assembly in a constitutional amendment. But the amendment that the National Assembly has done now, curiously, is that it says in that Section 138, subsection 3, that where the court makes a determination that an election is being questioned by a political party or candidate on grounds outside of those provided for under persons entitled to present petitions on grounds of, so that is the section above, the court shall impose penalties of no less than 5 million naira on the lawyer or 10 million naira on the petitioner. So the National Assembly, by this amendment, this means that the National Assembly, by this section, is arrogating to itself the power to amend the Constitution by an ordinary act of the National Assembly. In my opinion, they don't have the right. This section of that section 138 of the Electoral Act, to the extent of its inconsistency with section 138 and 182 and all other sections that provide that if you have presented a false certificate to INEC, you should be disqualified, you are not eligible to contest, is contrary to the Constitution and is therefore null and void. The National Assembly cannot, by this Electoral Act, amend the Constitution. And so this section is null and void. And I hope that people and lawyers will take note of it, that they can still file cases to court, to tribunal, on the basis of the fact that the persons have presented wrong or forged certificates to INEC. My name is Rimamnde Shawulu. This is The Other Side.